allow Mr. Caney to do the first section related to the unlawful claim or allegation of unlawful violation, and I'm going to wrap up with the rest of that.
Good afternoon. You haven't heard me talk officially in this proceeding. I'm Jay Caney from mckinnonc1.flv, Mr. Gardner's attorneys. And I too thank you all for your service and your patience in dealing with us in this sometimes contentious hearing. But we all got a job to do. As Mr. McKinnon just foreshadowed, I'm going to address the first round for dismissal that was set forth in the notice of dismissal issued by Mr. Reckenwald. Director Reckenwald. And that is, they fired our client for refusing to obey the order to produce his personal cell phone records that Mr. Pozo testified he was instructed to issue by the county attorney's office, specifically by Larry Smith, and that Mr. Pozo himself said he had questions about, and ran them back up the chain to the county attorney's office. That order. The order, and I'll get into it in more detail later, but what you've heard some discussion about how Mr. Gardner used his personal cell phone for county business, and therefore that opens the door for the government, make no mistake, that's what we're talking about here, we're talking about county government, the government to go look at his personal cell phone calls with Ms. Gittner and Ms. Winters. That dog won't hunt. Those are two different things. In terms of constitutional analysis, that's called a pretext. They don't use dog won't hunt in those cases. But at any rate, let me walk through the thing, because there's other points about that order that they tried to make. One was that this procedure that Mrs. Jones has referred to about complying with the unlawful order, and the other is running up the chain of command. And the evidence before this board is that in response to the order that Mr. Pozo was instructed to issue, he wasn't otherwise going to do, according to him, I sent him a letter. I got a little testy with him, sorry, Dwight, friends, but and it's in evidence. It's the December 12th letter, but it's important to go over this at this point in time, I think. Regarding order to produce, by the way, I didn't know he was instructed to issue the order at that time. I found that out today. This firm, and I told him that, the obligatory introductory paragraph, I represent Rich. I'm writing to respond to your order that you produced to the government his personal cell phone records. I asked him in the next paragraph to explain upon what authority he was issuing that order, because it doesn't say in the order itself. You don't have the order. And then I went in the next paragraph, and I prefaced it by, while I wait for your response, actually I said before I wait for a response, I should have said while, because that doesn't make any sense if I read it. I do note now that Volusia County Policy 27.01.36 states that all evidence obtained during an IA will be obtained in accordance with, and this is the CFA 27.04 Florida accreditation standards, so it's all relevant. And then went through the whole litany of the types of evidence that they can get through an internal affairs investigation. I don't know if y'all recall Mr. McKinnon putting that up and going through that with the witness. Okay, but I'll skip that part. And that I pointed out included, as you can see, personal cell phone records are not included as permissible evidence. That the policy is allowed to be used in an investigation. The order to produce records does not request a photograph, and I went all the way through the thing, how I didn't log any of that. I concluded, I made a point about the police officer's bill of rights and his procedural due process rights that we believe have been trampled throughout the process, and hopefully the court will do something to rectify that. But I concluded, in addition to not complying with being ultra-virus according to y'all's own code, not y'all's but theirs, I concluded that letter by noting that the order also violates Article 1, Section 23 of the Florida Constitution. That is the right to privacy that was elevated into the Florida Constitution in the early 80s by a constitutional amendment voted on by Florida voters, and there's a plethora of case law from the Florida Supreme Court where they have breathed life into that amendment. It means what it says. All right, so that, and in terms of going up the chain of command, it says to the director in the code, but by the time we got this letter from Deputy Director Pozo, Mr. Coffin had already been removed from the investigation, and Pozo was the one that we issued the order, so he's the one we responded to as the head of that department at that time. We complied with our order. Now, in response to his December 12th letter, I got another letter. This time it was from Mr. Smith, and as we've learned today, it makes more sense that he responded because it was really his idea to issue the order anyway. Plus, he's a lawyer. And that's the December 13, 2011 letter, wherein he cited there's been a lot of discussion about it. It's not evidence, but here's the case if anyone wants to read it. City of Ontario, California, not to be confused with another jurisdiction, versus Quan, K-U-O-N. And that is a United States, I think it's pronounced Quan. Forgive me if I got that wrong. It is a very recent, specifically June 17, 2010 opinion issued by the United States Supreme Court. And I'll be coming back to that in a moment. And so that's where that cite came from. That is the only authority provided in response to my request. What authority was that? Is the government seeking my client's personal cell phone records? There was no response, by the way, to the first point we made in the December 12th letter, that it's ultra-virus according to your own code, the accreditation standards about what is appropriate evidence in these types of investigations. And so, on December 14th, the very next day, this is December 12th, December 13th, December 14th, we weren't wasting any time here. I sent Mr. Smith a response to his December 13th letter, wherein I acknowledge receipt of his letter, and the purpose of this is to respond to your letter. And then in the second paragraph, and this is also in evidence, I say, in your letter you point to the following authorities: Beach Safety Division Directive 11.01.116, that was one thing he cited, and that case, City of Ontario versus Quan. Regarding the former, that is the Beach Safety Division Directive 11.01.116, you say that the order to produce personal cell phone records is in, quote, order from a superior officer which Captain Gardner is required to obey, ellipses, or face disciplinary action subject to dismissal, close quote. I then pointed out that begged the question posed by my prior letter. Again, and I cited section 11.01.116 provides, quote, employees shall comply with the direct orders or instructions given by a supervisor or superior officer and shall not refuse to comply when such orders or instructions are lawful and proper. And I had already asserted the unlawfulness of the order, and he comes back to, well, you got to obey superior. I mean, he just begged the question altogether. And so, and then as to, I reiterated within the code, VCBP policy 27.01.36 about the appropriate types of evidence that can come in. But then, going to what they've been reduced to relying upon is this case, the City of Ontario versus Quan. And I explain in this letter, that's what I say, the case you rely upon as additional authority is clearly distinguishable. If anything, it is support, and I've done more research on this since I wrote this letter, and I'm going to get into a little more detail in a moment. If anything, it is support for the position that the order is unlawful. City of Ontario versus Quan concerned a warrantless search. By the way, the facts there was a government employer seeking personal records of a government employee, right? Well, actually seeking phone records of a government employee, not personal. And so, and it concerned a warrantless search of pager messages to and from a pager issued by the city to a law enforcement officer with the admonition that it might be reviewed. It was a government phone, and when he got it, he was told up front, we can look at this, right? So those are the facts in that case. The facts in this case are a personal cell phone and no prior admonition. And not only does Quan say that, and I'll get a little more detail here. By the way, I elaborated on my reasons why that case has nothing to do with the facts of this case and therefore provides zero support for this unlawful order to produce records that Mr. Pozo unfortunately was instructed to give, even above his own questioning that he's told y'all about. To his credit, he saw that. But you know, he's following the order, which I think he should not have, but that's neither here nor there. He did fine. But in response to my December 14th letter, where I explained why the authorities they relied upon have nothing to do with these facts, or provide no support for that order, I got nothing. They never came back with explaining to me why I was wrong on that, or any additional authorities. Instead, the case proceeded until we served our written notice of violations of Mr. Gardner's police officer's Bill of Rights on December 21st. And then after that, we got a notice of dismissal without a new notice of intent to dismiss as required by section 112.533, subparagraph 4, subparagraph A. I'm reading the screen in the back of my head, I apologize. And so that tails off where I need to go at the moment. Sticking to this order though, the order violates the code, section 11.01.116, and I quoted that already. It also, that the order is also an attempted unlawful search is clear under constitutional law. I know y'all want to delve too deep in this, but that's the authority they're giving me to support the order. So I've got to gloss over at least some of this and give you some very basic precepts, if for no other purpose than to put it on record. Real simple. The Fourth Amendment is applicable to the states by virtue of the 14th Amendment, and it forbids governmental violation of, quote, the right of the people to be secure in their persons, houses, papers, and effects,